Hi, I'm Melissa Chonker, Executive Director of the New Jersey Foundation for Aging. Welcome to Aging Insights. Aging Insights is a production of the New Jersey Foundation for Aging. NJFA's mission is to improve aging in New Jersey and help older adults live in the community of their choice. Aging Insights is supported through sponsorships and viewer donations. If you're interested in becoming a sponsor, please go to our website at www.njfoundationforaging.org or call us in the office at 609-421-0206 for more information. We know that planning ahead is smart. Maybe you've read an article recently about getting your affairs in order, or a friend mentioned that they've seen a lawyer to create their will. What documents do you need? What purpose do those documents serve? And how should you get started? Today's guest is going to give us some of those answers and some more information. Joining me today is Carl Archer, an elder law attorney. Welcome, Carl. Thank you so much for taking the time to join us today here at Aging Insights.
Thank you for having me. I appreciate it.
Yeah. So just if we could get started with maybe you explaining a little bit of your history, what an elder law attorney is for people who don't know, and what functions your office might have.
Sure. So we have an elder law office in mostly central and southern New Jersey. We work throughout the state. But what elder law attorneys do is they help caregivers and seniors and people with disabilities with the legal issues that arise as a result of those issues, as a result of aging and disability. And so a lot of it turns out to be government benefits work, a lot of it is planning for the future, a lot of it is the conflicts that happen in families that go forward, and we have to try and help people walk through it because it's already a difficult time in their lives, and this could just make it worse.
Yeah, I think at some point we'll make the case for doing this sooner rather than later, because as you said, planning, much of what you do with folks is planning, and so it's easier to plan before a crisis hits, right?
I think it's about the only way to do it, yeah.
But we don't always do it that way, do we? So let's talk a little bit about planning, and people might be familiar with the phrase estate planning, and what does that actually mean? What does it include? Give us some more details there.
So if we just break the words down there for a second, when people talk about an estate, they're generally talking about money, assets, and an estate, strictly speaking, could be when somebody passes away, but people talk about it during their lives too. So when we're putting together documents and plans for people's future, we're doing it with an eye toward, let's make sure that nothing happens you don't want to have happen during your life and afterwards. The whole point is to avoid unintended consequences. Right. And those are the words I use with clients all the time. Let us avoid unintended consequences.
Yeah. I think that's really great way to phrase it for folks, and I think, people hear estate and they think, oh, well, that's people with a lot of property or a lot of money or a lot of assets. But it's about individually what you own and what belongs to you and what you'd like to see happen to it, yeah?
Absolutely. We're not all blessed with hundreds of millions of dollars, certainly, right. But some of the most complicated cases I've ever had involve people who have very little money, and the reason is because the legal needs don't change just because you have money or don't have money. Sometimes they're a little different, but the fact that we have legal needs does not change at all. Right,
and we joked a little bit about finding the right time to do this sort of planning, but really, people might think likewise of, oh, I don't have enough money to really need these documents. They might also think, well, I'm not old enough yet, or I don't think I have any needs, so I'm not going to do this yet. Is there a right time, or is there a time that you recommend people start considering looking into getting some sort of plan in place?
Well, to be fair, you can't execute any of these documents under the age of 18. Well, so let's start there. But and then I'll hear people say to me, "Well, that's great, but I'm not doing them at 18." All right, fine. But I have clients that will come in and I'll do a will or whatever, and they'll talk to me about their son or daughter who is going to college. Well, somebody turns 18. The fact that they're 18 now, you're a parent, doesn't mean you can make medical decisions, doesn't mean you have access to medical information, doesn't mean you can get into bank accounts and whatever else. So having a power of attorney and some sort of medical decision-making document for that person at that age is critically important, even though, if they're like most 18-year-olds, they don't have any money. That's fine, right. But what they might have is they might have some sort of a medical issue. Yeah. And you need to step in.
this is not just about what happens to your stuff, right? This is also about decision making. So what are the other critical sort of documents that go into estate planning? People might think, oh, I have a will, the money I have or the property I have is going to go to so-and-so. But what are the other things people might need besides a will?
So that's where we always talk about essentially three big documents. Okay, we talk about a will, and again, one sentence. The will is what happens to your stuff when you die. Okay, we can unpack that, but there you go. A power of attorney, which people will use that term power of attorney with medical things, but we're talking about a financial power of attorney. The ability to make legal and financial decisions on behalf of somebody else. That document should be in place so that if there's some sort of a problem, somebody can step in and take care of it. And then some sort of medical decision-making document. There are lots of medical decision-making documents, but the idea, again, is somebody can make those critical decisions at a time when you can't. And so you're covering the financial and the medical while you're alive, and then when you've passed away, somebody can handle the finances and get that stuff cleaned up at the end.
Right. So I like your phrase unpack. So let's unpack each of those individually and start with the will. I think your basic statement of what happens to your stuff when you die is a good general, layperson description, right, of a will. But what else would you like people to know about a will, or what other information is there that's important to know about a will?
Well, so I get people, this is where you hear people say, well, I don't have anything, I don't need a will. Maybe. The thing about a will and unintended consequences is that if you don't have a will and you pass away, the state has laws that determine what order things go, where they go, to whom they go. And, I'll hear people say, well, I don't want my money to go to the state. The money's not going to go to the state. But what will happen is, let's say you have a spouse and you die, all your money may go to the spouse, but if you have children without a will, some of it won't go to your spouse. Some of it will go to children. What if your children are minors? What if you didn't want to leave money to one of your children? Say one of them you didn't talk to, or one of them has lots of money and you want to leave it to the other one. Let's say you wanted to leave money to charity. You can't do any of this stuff if you don't have a will. And so, if you just want to make these things known, it has to be done with some sort of a document, or else the state says, well, it goes here, and then it goes there, and it goes there, and you just don't have the ability to dictate those things anymore. One of the other things that actually is interesting about a will is that you can name in a will who your representative is for purposes of a funeral, which you don't need to take the will to probate in order to use it, but you can name somebody to be in charge of your funeral, because in the absence of something like that, the state, again, determines who is in charge of your funeral. And so if you have, say, 3 kids, you need the kids to be on board. If you can't reach the kids, the funeral director can't reach the kids, that your body is going to sit in cold storage until somebody figures out, which is ugly. But again, this is one of those where if you appoint a funeral representative, it gets taken care of. The last thing is, without a will, you end up with what's called an estate administration. And an estate administration means, more often than not, that you have to post a bond in order to be in charge of an estate. So a bond would essentially be you getting an insurance company to vouch for the fact that you will not steal money that you're likely going to end up with anyway, which those bonds are about 1% of the value of the estate on an annual basis, which is almost always more than it costs to prepare the documents. And so you end up with a little penny wise, pound foolish here. And the insurance company doesn't mind, certainly, but I think you would.
Yeah. So the bottom line is, it doesn't matter, how much assets you have or how much property you have. What matters is that if there are specifics that you want in the event of your death, that you should write these things down and have them in a legal format, such as a will, and that there are additional things besides the distribution of assets, including assigning a representative to prepare your funeral, plan your funeral for you in the event of your death.
That's it. There's a lot of things you can do inside a will. Some of them, most of them deal with money. Some of them don't. And you know, having that in a nice, concise form really helps out.
Right. Absolutely. And it allows the person that you've designated or the appropriate family member to have something to guide them through making those decisions and following through on your written wishes rather than the state dictating.
It's a beautiful thing. Well, the will, you know, people say to me, well, what does an executor to a will do? You know, and you'll hear executor, executrix. The person who's in charge of a will, what do? They do what the will tells them to do. Right. It's very nice. It's instructions, 1, 2, 3, 4. Just set it out, and that's the way it goes. It's very, very simple that way.
Yeah, that's you know, I think a great coverage of that for our audience. So let's move into the second document that you mentioned, because that, I think, is sometimes a little bit more involved and requires some more explaining, and that's a power of attorney.
Sure.
And so you mentioned that that's primarily about financial and legal decisions. Can you tell us a little more about what a power of attorney does and why someone might need one?
Of course. So I would argue that a power of attorney is the single most important estate planning document that you can have. I had mentioned with a will, in the absence of direction, the state gives you an idea of what needs to happen. With medical decision making, oftentimes if you're next of kin, you can talk to somebody anyway, because there are some default provisions there. With a power of attorney, if you don't have a power of attorney, you can't get access to finances, period, without a guardianship, which means a court appearance and 6 to 8 weeks of delay probably from the time it's filed. And you've probably paid a lawyer, and a lawyer's been represented has been appointed, on behalf of the person you're trying to make decisions for. And you paid filing fees, and you're paying an insurance company. Lots of people make money. You don't, and your loved one is losing here. Plus, you've got all these delays, and this is oftentimes to the detriment of somebody you're trying to care for. So a power of attorney, again, the idea is you're allowing somebody to make legal and financial decisions, which is a very broad term. Okay, we're generally looking for powers of attorney to be what they call general and durable. And we can get into those words, but a general power of attorney means general, it's broad. It can cover just about anything. It's not limited to anything. You can buy and sell things. You can open and close bank accounts. You can sign your name to contracts. You know, something as simple as turning off the cable. A lot of times you need a power of attorney to get the cable company to recognize you. Because the cable company wants to get paid, you know, so, and a lot of it is, that's what it comes down to. So in order to step into the shoes of that person, you need to be able to do that right then and there.
So let's get into a little bit of the difference, because you mentioned general and just explained a little bit of what things could happen there. What is a durable, and how does that differ from a general? So
in the absence of any language to the contrary in a power of attorney is effective at a certain point, and it stops being effective as soon as somebody becomes disabled, which for purposes of estate planning is completely pointless. Because the whole reason to have one of these powers of attorney is so that somebody can step in and take care of things upon our disability or our sudden inability to act for some reason. You know, people talk about a general power of attorney and they say, well, that's very broad. What if I limited it? And I go, well, you know, we've all seen limited powers of attorney. Any of us who have ever bought a car before, we don't go to motor vehicle to get the plates. The dealer does it for us because they had to sign something that said, we can go to get the plates for you. That's a limited power of attorney. Well, you don't want to limit a power of attorney to specific things unless you know by looking into the future what specific things there will be that need, and this is not a game that I want to play. Right. And so banks don't want to play it either, because unless they have very specific language authorizing them to do whatever it is they need to do, they won't let you have access to accounts. So the powers of attorney end up being, 20 years ago they were 1 page. Now they're 5, 6, 7 pages, and that's not unusual. A durable power of attorney is just a paragraph in that it makes it durable by saying, this power of attorney shall not be affected by my subsequent disability, or words to that effect. So this way, somebody becomes disabled, the power of attorney is still good. And without that language, the power of attorney is garbage. You know, you also, on a related note, you want to make sure that the power of attorney is effective as soon as you sign it. Because the alternative is that the power of attorney is what's called a springing power of attorney. And they mean that, you know, if you think about it, kind of in the metaphorical, it springs into life as soon as you are disabled. And while there is a legal definition of disability, there is not a legal requirement that a bank or somebody else accept your proof. They may look for proof that is acceptable to them of your disability, which means every single bank, institution, the cable company, everybody might say, we want different doctors' affidavits, we want them dated within a certain day, we want them to meet a certain form, we want whatever requirements, which just takes time, and that is time that's better spent in a crisis. You don't have the ability to, that's not what you want to be spending your time on.
So for purpose of example, if I had a sheet here that said, you know, I want Carl to make, you know, banking and financial decisions on my behalf, and I signed it right now, and we took it to the bank, you would be allowed to make those changes. But in a springing, it would say it can only be used if Melissa is disabled and she's not able, and a doctor can provide documentation of that. Is that a correct assessment of what you've said?
Sure, it's a little on the simple side,
Right.
but I'm going to go with it for yes.
Yes.
That is the idea. If it says it's only effective when Melissa's unable to make decisions, then that is a springing power of attorney. If it said, I authorize Carl to do this, and oh, by the way, it's effective as soon as I sign it, great. Then I'm going to take it, and I'm going to go get filthy rich, because I'm sure, you know, that's what's going to happen.
Absolutely.
Yeah, absolutely.
So I'm glad you've mentioned that, because sometimes there are concerns about financial abuse or fraud, and if you've given someone the authority to make decisions for you, we've seen that people can sometimes misuse that authority. And so could you speak a little bit to that and maybe some cautions or protections in that area?
Well, and so one thing we always tell people is you have to be really, really, really sure you trust the person that you're putting down as power of attorney. The will, listen, I get that you want to trust the person who's the executor, but you've passed at that point. You know, the power of attorney could affect things that happen to you during your life. It could affect the quality of your health care. It could affect your access to health care. These are things that, you know, your ability to stay in your own house. These are things that we really need to have control over, which is why I said that I think that the power of attorney is the most important of the documents, because it affects what happens during our lives. And so, you know, I'll get people say to me, well, you know, what if this person goes and steals my money? I said, well, why are you putting them as a power of attorney? Don't do that. Right. If you trust them, write them down. But understand that the person you write down has the ability to do basically all these things. And so you don't want to put anybody down there who you think is going to help themselves to your money and go out and buy a sports car, you know, or say, well, I deserve this, or whatever. You don't want that. The person needs to act in your best interest, which is harder than it sounds sometimes.
Yeah, it's a big responsibility. And so I think while we can't predict the future and you don't know how every person is going to act, it should be someone that you're confident enough in that you believe would act in your best interest, and that you've had a conversation with about their role in acting in your best interest.
That would certainly help.
Yeah, okay, good. Just making sure we're covering that piece as well, and you're not just listing people without telling them, which
you could do.
You could do, but
I could go skydiving. It doesn't mean it's a good idea.
Exactly. Yeah. That's great. Which, you know, leads right into having conversations, I think, around the medical decision-making documents. This is where it's most important to have had a conversation with someone as you're creating these documents, to make sure that if you are assigning someone to make decisions on your behalf in medical cases, that you've talked to them about what your wishes would be or what your general thoughts are on.
Ultimately, you want them to do what you want them to do. And if you haven't had a conversation with them, I don't know how they would be able to make those decisions.
Yeah. So you mentioned that there are a couple of different types of documents and a couple of different types of ways to make your medical wishes known. So can you talk us through sort of some of those medical, I know there's medical power of attorney and there's some other things.
So lots of documents, okay, which I'm not getting into, but you hear about healthcare power of attorney, you hear about 5 wishes, you hear about living will, proxy directive, instruction directive, you know, advanced medical directive, you hear about a post, we can get into the post. So all of these documents, they fall into 2 categories. What are your wishes? Who do you want to have carry out your wishes? That's it. Two. That's it. That's all you've got. And so you can have a document that does both, or one or the other. And so that's what you're looking for ultimately, is you need to make sure that there is some way that your healthcare wishes are communicated, and you have to make sure that there is a person who is able to carry out those wishes when the time comes. That is what you need to have in place.
So in terms of a document that names someone to make your decisions, is that called a healthcare proxy? Is that one of the names
that is among them? Yeah. So there are a lot of forms out there that'll you'll hear somebody named as a representative or as a proxy or something like that. Proxy being one to step in the place of another, just kind of how that word works. Yeah, and that's very commonly how it's done. And then you'll see something called an instruction directive, which again is the same thing. It's here are my instructions. I am directing you to follow instruction directive. There you go. Sometimes these words make sense.
Yeah. Sometimes we're using the right ones.
And so you'll see a document often that'll have a proxy directive and an instruction directive, and they jam them together into one document, and there you go.
Right. And so an advance directive or a living will, or you mentioned 5 wishes, which is a document that people can find on the internet that allows you to answer some questions about what your wishes would be. Those are the instructions that you're referencing. Those are documents that you can create that say, I do want this, I don't want that.
Right.
But ultimately...
And my thought process here is you should have either, and the instructions can either be written down or it can be part of a conversation. I always recommend a conversation, even if you have written them down, because sometimes it changes and you need to make sure that people know. And I'm not expressing an opinion as to any particular document here, because we don't have that kind of time and nobody wants me to get on my soapbox. But the idea here is, again, instructions. Somebody should know about them. And that person preferably is the one who's making the decisions. Right. And as long as that is the case, then you should be good to go.
Yeah. We often advocate, obviously, that there is no right time to have the conversation, but it's important to have the conversation, and more so if you're naming someone as a decision maker for you in the event that you have a medical issue that requires someone else to speak on your behalf.
That seems eminently reasonable. Yeah.
Yes. So with all of these documents and all of the things that go in and out and the things that we've covered and the things we don't have time to cover, how do people get help learning more about this? Is there a way to find an elder law attorney that people can then make a phone call to someone in their area and say, I'm interested in learning more about these documents and possibly creating a plan for myself? Sure. How do they go about that, finding someone?
So the one thing that I'm going to not recommend that they do is go play Google lawyer.
Yeah.
And and listen, on my website we have lots of educational content, but you got to be careful with your educational content, because if you just do a Google search for what is a will or what can I put in a will, you're going to get 100 different things, and you're going to get things from different states, and some of them are going to contradict one another. And unless you are really careful about it, you're going to either spend a tremendous amount of time on it, or you're going to get contradictory information, which is bad. Yes. Okay, because you get one shot at this if you're going to just sign it, and if you've passed away, it's too late to change it. So, Googling around is okay for basic information, but it's difficult to get specific information for your case. Likewise, maybe I'm a little biased, but I caution people away from your online document prep services which I'm not naming names, but you can go on and pay a few bucks and they'll give you this document and say, here, go get it signed. I would say approximately 90% of the time I see a client come in with those, they've been signed improperly, or there are things that are contained in them that don't work in New Jersey, because they say the form works in New Jersey or Pennsylvania or New York or whatever jurisdiction we're talking about, but it doesn't. Or it doesn't have enough witnesses, has too many witnesses, the notary language is not right. There's 100 things that could go wrong. Whereas if you just look at it and you do this all the time, your forms will be what they are. I always say to people, if you're in a position where an elder law attorney would be useful, we're dealing with aging related issues, we're dealing with disability relating issues, you're going to go see an elder law attorney. There are 2 good places to go to find that. There is a trade group for elder law attorneys. There's over 2,000 attorneys that belong to this, and in order to be in this group, you have to do this as a fair amount of your practice. It's called the National Academy of Elder Law Attorneys, and the website is www.naela.org. Okay. All right, nothing creative there, it's just the abbreviation. Well, they have a directory on there of attorneys, and you can go in and put in your town or your zip code, and they'll tell you who the ones that are closest to you, which I'm not saying that those people are all the best elder law attorneys in the world or all the best attorneys in the world, but in order to be a member of NAELA, you have to spend some money to be a part of it. You have to have some interest in it, and there's a pretty good guess that you have some expertise in this.
There's some level of vetting there rather than, as you said, just an internet search that might provide you with a generic document.
Yeah, you do an internet search, and anybody who knows to get the right keyword or pay for the right ad, you get an issue. Yeah. If you have an issue that requires a little bit more sophistication, or you have an issue where you need a specialist, what you end up with is a group called the National Elder Law Foundation. They certify elder law attorneys. So through the American Bar Association, there is an accreditation for elder law attorneys, and that there's about 400 of them in the country, 50 of them in the state of New Jersey, because it's a tough place to grow old in New Jersey. But you have, that's NELF.org. And again, they have a directory you put in your town, and they'll give you the ones that are closest to you.
I think that's wonderful that we can give people two places to go to look for folks that might be practicing elder law in their area, and that they can get more advice. I thank you for the information and definitions you have given us, and certainly it's great for people to know where to turn if they have more questions than what we were able to answer today together. So
of course.
Thanks again for being with us today, Carl. Really appreciate it.
It was my pleasure. Thank you.
And thank you for watching this episode of Aging Insights. For more information and to watch previous episodes, you can visit our website, which is www.njfoundationforaging.org, and click on the Aging Insights page. Aging Insights is produced by the New Jersey Foundation for Aging and is made possible by sponsors and donations from viewers like you. To become an Aging Insights sponsor, you can visit our website or call us in the office at 609-421-0206. And to find out about senior services in your area, please contact your county office on aging. Their numbers can also be found on our website, or you can call the state hotline at 1-877-222-3737. Thanks for watching, and be sure to tune in next time.